gonna backtrack. And you should've kept my name out your mouth. As we go, how it all turned out. When you try to use my name for clout, keep on going, think it's something you could talk about.
Hello, everybody. How are you doing this fine Thursday, September 25th, 10:11 a.m. I interrupt my, I guess, regularly scheduled David and Celeste coverage this morning for a Diddy update. Okay. He does have a hearing this morning at 11 o'clock a.m. Right now it's 10:12 a.m. I am a little bit early, which is not usual. Please do not get used to it. But not that early, just a couple minutes. But yeah, shout out to the cousins in the chat. Cheyenne said BJ has become part of my daily routine during the week. Love that. Love hearing that. Crystal said 7:12 over here. Good morning. You're helping me get ready for work. You must be on the West Coast or somewhere over there. Oh, that's so cool. Shy One said, loving these daily hour-long lives, girl. They hours long. I know. I work from home and it helps me get through work. Shout out to you. Oh yeah, I forgot to pull up the Shakaya. Or is it Shakia or Shakaya? I would say Shakaya. I forgot to get the Diddy song ready, and then it was like I didn't really have time and all of that, so I just didn't want to be late. 3:12 p.m. Shout out to the Irish cousins. Thank you so much, AI Evolution Rookie Brand Creation. BJ, your hair is giving beautiful. Thank you so much. It's getting a little tangly. It's getting a little, as the UK cousins might say, a wonky. But thank you very much. Okay. All right. So Diddy's got a court date today. All right. He's got a court date today. It's not the final one, though. He has one big final shebang coming up next week. At the end of next week, it's going to be the sentencing hearing. He's going to be sentenced at the end of the week. Next week, October 3rd. I will be covering that live as well. Is my necklace an anchor? No, it is called a khanda. It's like a symbol from Sikhism, and it is like one double-edged sword, two swords here. They have all these meanings and things like that. Yeah, one thing I really like about the Sikh religion, I don't practice a religion personally. I wouldn't call myself like specifically anything, but I really like, if I had to pick religion, I really do like that one. They are a warrior people. Okay. They are not, I would hardly say they are a pacifist religion. All right. These people are warriors. One of the things that they do, like the very devout Sikhs, is they actually carry around a knife. It used to be a big sword, but it's kind of hard to get through the airport. Okay. So they carry a little knife. Anyway, I actually got this is meaningful to me because I got this as an engagement present from my in-laws. So that's why I wear this all the time. It's not an anchor, but I could see how it could possibly look like that. Some people say it looks like the thing from Star Wars. Whatever. Anyway, Khanda, Khanda, I think is what it's called. What outfit? This is like an Arkley dress. Let me do a fit check. Because the hearing doesn't start for 45 minutes. I want to come on here early. So again, I'm always wearing these dresses, but then I have just like regular sweatpants under them. So it goes like all the way down to the floor. It's like a long dress. It's not called an anarchally. This is actually called something else. I don't know, where the like hemline goes kind of like up, but anyway, it's got little flowers on it. Anyway, okay. So fashion show moment. Okay. So why are we in court today? Why is Diddy in court today? He is in court because he has motioned the government for a new trial. Excuse me, the judge, the court. He's motioned to the judge for basically he's asked to be acquitted. He's asked to basically be, not guilty of anything, even though he's already been found guilty. And if the judge won't give him this acquittal, grant an acquittal, judgment of acquittal, then he's like, okay, well, if you don't do that, then I also am asking for something else as a backup, as a plan B. And he's saying maybe, it's not Ampere, but like Ampere goes under the bust. like slightly, I think, but that is close. This one is like goes on top. It doesn't like fully go down. But anyway, yeah, no, I like to be covered up. I don't need everybody seeing all what the Lord gave me. I mean, listen, I was breaking it down for the 99 and the 2000 just like everybody else. All right, don't get me wrong, but I'm in my anti era. So he's supposed to get sentenced. Diddy is supposed to get sentenced on October 3rd. That's Friday, coming up next Friday. So it's like a week from tomorrow. But before that, he's like, wait, hold on. I want to be found like acquitted of all this stuff, Your Honor, please. I don't, I'm tired of this. Just no, no. So really, we have two major issues up for the judge to decide. The first issue is like, is he going to do this acquittal slash new trial thing? And also, what is Diddy going to be sentenced for? So it is two different things going on right now. Um, yep. Yep, this is exactly right. I know I'm kind of bouncing back and forth like while I'm sort of getting on track here, but again, it doesn't start. The hearing doesn't start for another 43 minutes. So we're just kind of catching up, getting the context, getting what's going on so that when the hearing starts, we're kind of caught up. Because I haven't talked about Diddy in quite a while. Vonagles said, much love to all, but remember, religions are mostly man-made. Another way to divide, keep open minds, guys. Exactly. Exactly. Me personally, I do believe in God. I believe in the one true God. And I happen to believe that a lot of religions believe in that same God. And, there's just different paths into the kingdom. There's different portals into the kingdom. Some people really need to subscribe to one and some people really don't. Now, this is different from like being an atheist, which I actually would say I used to kind of be an atheist. Like I grew up Christian, but then it was crazy. And they, I felt like they just didn't know how to act in the church where I grew up in. So I was like, ew, no, God must be fake or whatever. But then as an adult, I started to come around more to my own understanding of the world and spirituality and myself and what that even is and all that. But totally agree. I do not subscribe to a specific religion. I mean, I reserve the right to change my mind. I might one day, but I don't right now. Anyway. So shout out to the one true God. All right. So first thing I thought we could do is actually just take a look at Diddy's motion itself for the acquittal and the new trial, just so that we can get an idea and an outline of what types of things he's arguing. I will tell y'all, I don't think any of his arguments are very strong. The strongest argument I think that he does have is this amateur pornography argument, where basically he's saying, this is a First Amendment protected activity to make a movie for myself to watch later. And so for that reason, I shouldn't be have found guilty on the Mann Act charges. I don't think that's a very strong argument either, but I do think it's the strongest argument that he has because it is based on like strong constitutional principles. That being said, it's still, I don't think, going to get him very far. Many reasons for that. The first reason is that there's actually like rules that you have to follow in movie production. And in particular, there's rules you have to follow in production of adult films like that. You have to get waivers, you have to get things signed, you have to get, I don't know, I think there might be unions for that. I mean, there's all kinds of things you have to do. You have to keep certain things on file for years. It doesn't appear that that's what Diddy was doing. So it's going to be kind of hard for him to argue that he was making amateur pornography whenever, he doesn't appear to have actually been following any of the rules to do that. Number two, he really never made this argument before. So you can't just bring something up for the first time that you could have and should have brought up earlier after you already got found guilty. It's kind of like, too little too late. There's many other reasons why I don't think this argument's going to get him very far. Specifically, another one is that this is not the appropriate forum to bring a constitutional issue such as this. What he's basically trying to argue is that the Mann Act itself is unconstitutional. It has been selectively enforced against Black men. He might even be right about all that stuff. I'm not arguing with him whether or not it's been selectively enforced. I haven't done a survey. What the issue is he did already try to make that argument once or twice in this court already. And Judge Subramanian, who is a man of color, who is not a white man, he kind of shot down these arguments already. So Diddy is kind of bringing these up yet again. He's already brought them up. On top of the fact that he has not brought up this corn argument before specifically. Now, he has brought up the Mann Act argument, it being unconstitutional or whatever. And it might be. I'm not even trying to get into whether or not it is or it isn't, but judges don't make laws. Legislators make laws. Y'all remember the Schoolhouse Rock? Put emoji in the chat. Put a music emoji in the chat if you remember Schoolhouse Rock, telling you how a bill becomes a law and all that. And then there's these branches of government. There's three branches of government. There's the executive branch, that's the president. There's the judicial or the judiciary, the judicial branch, that is judges and people that do adjudication, like arbitrators and stuff like that, if it's government involved. And then it's mostly judges, people over tribunals. And then other than the executive, which is like the people you vote for, um, to be mayor, to be president. Then you have judges. And then there's a third branch of government in the United States. This is called the legislative branch. That is who writes laws. That is who passes laws. How a bill becomes a law. This all happens in the legislative branch. So technically speaking, judges really aren't supposed to be writing laws or putting laws into place or vetoing or overturning laws that Congress made. There's some limited exceptions where judges can do this, where, let's say there's like a really racist law put into place that's like frankly unconstitutional. Like let's say people beyond a certain skin shade can't come into this city hall or whatever. People lighter than a certain skin shade can't come in here, or people darker than, like, this is like blatantly unconstitutional, like factually, just like absolutely no question. So let's say like the legislative branch tried to put a law into place that had something to do with skin tone and going into a public building or something. Yes, in those cases, a judge can jump in and say, I don't think this is constitutional. I'm not going to enforce this law in my court. I'm going to say it's unconstitutional. But even that, right, it has to go through all these levels and layers. It's like something totally different than just, a judge deciding, oh, yeah, I don't like this Mann Act, so I'm not going to like apply it to Diddy, even though a jury already found him guilty. It's just not how it works. So that's kind of the primer. Let me pull up his motion for a new trial, or for acquittal, or in the alternative, a new trial. This is document number 486 on the Diddy docket. Shout out to Diddy docket if they're in here. Okay, so I have the document up. Whose birthday is it? Happy birthday, whoever's birthday it is. Shout out to the cousins in the chats. Oh, it's Empath's Rhapsody. Happy birthday to you. Thanks so much. I'm blessed that my heavenly Father has given me 44. Ooh, it's your 44. That's a good year. On this earth, and baby, she's still looking like 31. Okay, this Jamaican melanin is not cracking. I mean, that's what I heard. Obviously, I would have no personal experience, girl. I have to be down the skincare aisle. I have to be putting all the oils and potions and things. I'm cracking. I am cracking at 35. Okay, I admit it, but I do stay out of the sun. That helps. Shout out to you, 44. I love like double numbers like that. 22 and 33 and 44. I just like it. Okay. So here's the document. This was filed on what was it? Was July 30th. Okay. Diddy filed this, 62 pages long. We're not going to read it all. I'm just going to kind of run through his arguments with y'all. And then we're going to go through the governments. And when I say go through, I'm really going to spend like just a few minutes here. This is not going to be a breakdown of the whole thing. I just want to get y'all up to speed so that in 35 minutes when the hearing starts, we actually know what's being talked about here. Again, if you're just joining, hi, hello, make sure to click the like button and take your shoes off on the way in. And just to let you know, there's two big major issues going on right now in the Diddy trial. One big major issue is today, and then another big major issue is going to be at the end of next week. That is his actual sentencing hearing. That's next week. This week, he's actually trying to get acquitted. Okay, he's trying to get a motion for a new trial. Now, there's a lot of people or a motion for a new trial. If he doesn't get acquitted, he's then asking, okay, plan B, I want a new trial. That is what they are going to be doing oral arguments for today in about 34 minutes. This document is his request for that. Memorandum of law in support of defendant, that's Diddy, renewed motion for judgment of acquittal, or in the alternative, he wants a new trial. Okay. So then they get through their table of authorities. I'll read through the table of contents because it does give you a nice roadmap. There's the introduction, and they go into the background. The background starts with the procedural history of the Diddy case, what actually happened in his trial, and then the history of what they are calling the White Slave Traffic Act. Okay, that is not what this act is called. So you can see that Diddy's lawyers earning every bit of their paychecks. I got to give it to them. I mean, they're really good lawyers. They're good at being lawyers, but just probably going to hell, kind of situation. So they're calling the Mann Act the quote, White Slave Traffic Act. I do not know why they are calling that. I mean, I kind of do. Hold on. I need to move this so I'm not like out of the screen. I do know why they're calling it that, because they are explicitly saying that Diddy has been racially targeted with this prosecution. And I don't think so. Okay. But listen, I don't know. Anything's possible. Anything's possible. The issue is a jury already found him guilty on it. So they're basically going to have to get the judge to like declare this thing unconstitutional, which he's very, very unlikely to do. And even if he does, it's subject to be appealed. And then, what else? Yeah, and they also have to get the judge to overturn a jury verdict, basically, because a jury already found him to be guilty on those two charges of Mann Act violations. Okay, so they get into the history of this, quote, White Slave Traffic Act. They say the original purpose of the statute was targeting commercial traffickers. Okay, and they're trying to say Diddy is not a commercial trafficker because he wasn't doing this for commercial gain. He was doing it for his own personal gratification. If anything, he lost money doing this, which, okay, fine. All right, fine. No problem. The act became a tool for selective enforcement of, quote, moral standards, is another part of their history of this Mann Act part. Now, probably they're right. I'm not going to argue on this one. They're probably right that the Mann Act is selectively enforced. There's probably all kind of people out here doing the same exact thing, never got prosecuted. Do I think it's a race-based thing in this specific case? No, I don't. I don't think that Diddy got singled out because he's black. And I know a lot of people are probably thinking, well, what about Donald Trump? Good freaking question. Maybe he should be prosecuted. Okay. I'm not even trying to say he shouldn't be. All right. I don't know why it is. Every time I'm talking about Diddy, people always want to bring up Donald Trump. Like, I don't know if y'all knew this or not. I don't like that man. I never liked that man. I never even thought, ever even considered voting for him. Not one day, not one moment, not 1 second in my life. And I would never vote for him. Okay. So I hear you on the selective enforcement, but in this Diddy situation, I don't think it was, oh, Diddy's black, let's get him with the Mann Act. I actually think he pissed somebody off real high up with that Diageo lawsuit, and that got him in this type of like trouble because he wasn't being protected by high ups anymore. I mean, that's my conspiracy theory, but I don't know. I wasn't there. Anyway, so this whole section right here, B, Diddy's lawyers are arguing that the Mann Act, which is the interstate transportation of basically like an S worker or somebody, anybody, even if they wouldn't, be considered an S worker, or you wouldn't consider them that, like transporting anybody across state lines, causing them to be transported for a so-called, quote, commercial S act. Diddy's saying this don't even apply to me, first of all, because it wasn't a commercial S act. However, the government does come back around and they file their own filing about a month after this, and they say, yes, it was, because you paid them. You paid the entertainers when they showed up, or you caused them to be paid. It was your money somebody handed to them. So it was a commercial S act. I do agree with the government on that one. However, Diddy has other arguments. He says the Mann Act also became a tool for selective enforcement. They're selectively enforcing this onto me and not others. Now, what I will say is the judge has already kind of addressed this and disposed of the argument. Including whenever Mark Agnifilo, Diddy's lawyer, was trying to do his closing arguments, and he was saying the government is only targeting him because he's black and only because he's a rich black man and all of this stuff. And it's like, there's just no way that's true, first of all, because there's so many rich black men that are probably, the real famous ones we all know about. I'm not going to name any names. I ain't trying to be in a lawsuit and have DJ Academics and Aiden Ross get mariachi bands at their house to try and get served and stuff. I'm just not trying to go down that path. So I will just leave it to your imagination. The other black men who are very successful and even way more rich and way more successful than Diddy, who are probably out here doing pretty much the exact same type of stuff. So why aren't they getting, if it's just selectively being enforced against black men, then why aren't they actually being charged? They haven't been. So again, I can go so far as to accept that this Mann Act has most likely been selectively enforced. I can go so far as to say probably it was racial. But I'm going to stop right before we start acting like Diddy's being selectively prosecuted because he's black. Because that part don't really make sense to me. Now, if he was a little bit lower level, maybe so. But y'all can make your guesses if you want to. I'm just not going to say it. I have had enough legal disputes for the past 5 years. If I could just stay out of them to the back. I mean, listen, I win, always win, but they have chilled my speech out here. Okay. So he goes on, he says, there was in the history of this Mann Act, there was backlash against the overbroad decisions in these cases. There might have been, I'm not even gonna disagree with him on that. I don't have enough information. They might be right there. And then it says the Department of Justice has long declined to enforce these other precedential cases. Number 4 is a non-starter. I'm going to actually just put a strike through on that just to let y'all know how bad of an argument I actually think it is. So let me do that. The Department of Justice changes over every 4 years when a new president, comes in. Sometimes they decline to enforce things. Sometimes all of a sudden they start enforcing it. Just look at what they're doing with ICE right now. They've always had this same enforcement power to do what they're doing right now. They just haven't. They just haven't done it. So while it is an argument that you can make and it can be compelling, like, okay, well, they never used this law against anybody before and now all of a sudden they are, that could be explained by like the turnover of a regime change, as it were. I don't think that's the strongest argument to get your whole trial overturned. Okay, that's basically what I'll say. They're arguing there was insufficient evidence that Diddy transported anyone with the quote intent to engage in quote stitution. All right, that again it seems like some of these arguments are like, okay, I see what you're doing there. I gotcha. And some of them are like, girl, why did you put that down on this paper? It makes everything else look insincere. It's just like, please, there was insufficient evidence that Diddy transported anybody with the intent to engage in prostitution? Please, a jury found him guilty on only those 2 counts. They only found him guilty on those 2 counts. So they must have found that there was sufficient evidence. And again, y'all, listen, Diddy could have had this whole trial in front of only a judge. He wanted a jury. He requested a jury. He had the right to a jury and he got a jury. So now he's like, oh, there wasn't enough evidence. Like basically he's just saying like, oh, I don't like that I got convicted on 2 things. So I want to tell you how the jury got it wrong. It's like, it's a little too late for that. The Mann Act, again, they're taking issue with this Mann Act. It should be narrowly interpreted to avoid serious due process, First Amendment, and federalism problems. Federalism is the conflict of laws between state laws and federal laws. There's due process problems. There's substantive due process problems. The Mann Act is just too vague. There's First Amendment issues. There's federalism issues, and we just can't have this apply. They want it to be narrowly construed. So then they get to number. Okay, so in the background, Section B, and in the argument, the entirety of Section 1A all has to do with Diddy and his lawyers taking issue with the Mann Act itself. I've already laid out the arguments as to why I don't think that's going to get him very far. I won't get into doing that more here. You can rewind and look back. Okay, then they're like on B, argument 1B. This is kind of when Diddy finally starts to actually argue. Like, all right. If the judge finds that he is well within, like properly found guilty under the Mann Act, there was no constitutional problem, no due process problem, no none of that. And the act, let's say it does apply to Diddy. Then Diddy's saying, all right, fine. Next argument. The Mann Act does not prescribe it doesn't prohibit this conduct by Diddy because he, quote, lacked a commercial motive. He did not intend for the paid escorts to have relations with him. Now the government comes back later in their filing and says, yeah, he obviously did intend for them to be there for him to do an S act. Just because he was sitting over there not touching them in the corner, he was in the room taking care of himself, doing a S act in the same room with these people. That is an S act. Yes, just because they didn't have some type of penetration or something doesn't mean that it wasn't a commercial. It wasn't being paid to have relations, quote, with him. He was in the room. You know, that's what the government argues. We're going to have to see what the judge decides on whether or not he buys that or not. But then Diddy is saying that there is no commercial motive. He had no commercial motive. Well, if he intended to pay the escorts, which he clearly did, because we do have evidence at trial that comes up where he's like trying to get a discount because he's a regular and all of this stuff. Like he knows that when he flies somebody out, he got to pay him. Okay. So again, I think he did have a commercial motive, and the commercial motive was to pay the entertainers to participate in the S act in the same room with him. But again, I mean, he's kind of nickel and diming. He's kind of getting in the weeds. In the semantics. So we'll see what's argued today. Coming up in about 22 minutes, the hearing is going to start for oral arguments. He says there's insufficient evidence that Diddy transported anyone with the intent to engage in legal definition of stitution, even if it includes any sex for money. And now they saying upholding, this is argument number 2, upholding the convictions would violate the First Amendment because paying people to film them in sexual performances is protected by the First Amendment. Oh. Diddy's conduct was protected by the First Amendment, they're trying to say, because he was doing amateur porn production. Again, I already discussed earlier why those arguments are going to be difficult to make, namely that he didn't do any of the stuff he's supposed to do. Like there's rules in pornography production. He did not do those things you're supposed to do. And I don't think he really made this argument at all ever before. Like, oh, it was amateur porn I was producing. Like this argument was never made. The jury never even heard that argument. I mean, they might have heard the statement be made, but I don't think it was like adjudicated. Okay, so they're saying it was protected by the First Amendment to fly somebody out and have them have relations with your girlfriend who you provided substances to. And when they ran away, you chased her down the hall, beat her and all that. Like that's First Amendment activity. Okay. Then the last argument he makes here, the last section of the arguments is at a minimum, a new trial is required due to spillover prejudice from evidence that would have been inadmissible had the Mann Act counts been tried alone. He's basically just saying here, well, if they would have just never tried Diddy with the stuff he was found not guilty of, right? There was 5 acts they charged him with. RICO was 1. S trafficking was 2 and 3, or 2 of them, 2 out of 5. And then this Mann Act, this transportation for the intention to engage in a commercial S act or prostitution is, hold on, I get distracted, is what he was found guilty on, those 2. But the other ones he was found not guilty. So basically he's saying here, well, Your Honor, if they would have just never brought those charges that I was found not guilty on, then a lot of that evidence wouldn't have been presented to a jury. And so for that reason, I should get a whole new trial with a whole new jury for this institution thing. And basically, he wants another bite at the apple. He wants another try. He wants another stab at the trial. And it's just, in my opinion, it's just too late. In my opinion, it's just too late. Right. Right. Cheermaster said, wait, the pre-recorded corn that he used to blackmail his exes to comply with what he wanted, allegedly, according to evidence presented at trial. I mean, that's they're out of their mind. I mean, it is a little bit cuckoo. Okay, so something wrong with him, clearly. I'll bring up quickly the government's rebuttal argument here, the opposition, just to kind of give you some idea of what they've said. But I did already really lay it out. Pretty much the substance of the arguments. This is what we're going to be observing today from the hearing, oral arguments. Okay, so the government's memo for opposing Diddy wanting an acquittal. Okay, so their argument, first of all, the court needs to deny the motion. His statutory arguments, first of all this stuff about something being unconstitutional, that this is not the appropriate forum. He needs to bring that up to somebody else, like maybe a legislator or something. The Mann Act, as it stands, covers his conduct. The court's definition of stitution is appropriate. Diddy's like, oh, I wasn't doing stitution under the definition. The court defined it weird. The government's like, shut up. This is how we always defined stitution. I don't know why Diddy wants a extra special definition because he don't like the outcome of his trial or whatever, but that's just not going to work. Is basically what the argument is from the government. The court should decline to employ the doctrine of constitutional avoidance. That's kind of a canon of statutory construction. I'm not going to get into that. Number one, the Mann Act is not ambiguous. They're trying to say it's so vague, it's overly vague. No, it's not overly vague. If you transported somebody across state lines for the purpose of engaging in an S act, which counts as a commercial S act because money was exchanged, change hands, no, it's not vague. It's very clear, and it clearly applies to him, and he clearly was found guilty, is basically what the government is saying. They say the Mann Act does not present constitutional concerns. There are no vagueness concerns as to due process like Diddy tries to argue. No, there are not. There is no substantive due process concern. There is no federalism or conflict of laws concern. And there's definitely no First Amendment concern. No, 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 says the government. The defendant, that's Diddy's purported First Amendment concerns, are meritless. Like the ones about, he was making amateur corn. That's meritless, they say. There was sufficient evidence for a rational jury to find the defendant guilty of these two counts. The court should deny Diddy's motion for a new trial, et cetera, et cetera. So I'm just going to read the first couple paragraphs here. Government respectfully submits this opposition. The defendant, following a conviction at trial on 2 felony Mann Act counts, advocates for the court to narrow the scope of the Mann Act to exclude his own criminal conduct on the grounds that, among other things, the statute is vague, violates his due process rights, and his First Amendment rights. The defendant, that's Diddy, further contends that the record at trial doesn't support his conviction. They say he is mistaken as a matter of fact and law. As an initial matter, because several of the defendant's Rule 29 arguments address alleged constitutional issues, these are untethered to the sufficiency of evidence. These are not properly raised in this forum. They can be rejected just on that alone. However, the government says, even if that wasn't the case, his arguments still fail. This is so shady. While the defendant may wish to limit the provisions of the Mann Act to suit his own purposes, the terms of the Mann Act are not ambiguous. Contrary to Diddy's arguments, whereas here the text of a statute is clear, the doctrine of constitutional avoidance is inapplicable. So again, I don't want to spend the time to get into this constitutional avoidance principle of statutory construction. It's just a little bit, again, in the weeds. I don't think it's necessary to get into here. I don't think that Diddy's going to win on this argument. So I don't really want to waste the time. The Mann Act, the government says, is not unduly vague, nor do its provisions run afoul of substantive due process. They also don't pose federalism concerns. Equally, Diddy fails to raise any legitimate First Amendment concern because his conduct, this is a quote, is clearly not entitled to First Amendment protection. Okay. His conduct is clearly not entitled to First Amendment protection. Further, at trial, there was ample evidence to support the jury's convictions. Diddy masterminded every aspect of the freak-offs. He transported escorts across state lines to engage in freak-offs for pay. He directed the activity of escorts and victims throughout the freak-offs for his own gratification, and he personally engaged in S activity during freak-offs. There was more than a sufficient basis, viewing the evidence in the light most favorable to the government, to support the counts of conviction. Finally, Diddy fails to present any basis for a new trial. The defendant's retroactive misjoinder argument is without any merit and should also be rejected. There's no precedent or legal basis for a new trial based on this. Oh, if they only charged me with the stuff I was actually found guilty of, I would have been found innocent of the other. Like that, what? This brand new, he just pulled that out of the thin blue sky. The defendant suffered no impermissible prejudice. Accordingly, and for the reasons stated below, the defendant's motion should be denied. He transported, aided, abetted, and willfully caused to transport multiple individuals. He asserted substantial control over Cassie and Jane's lives. As part of these nights, he required Cassie and Jane to have relations with commercial S workers while he directed and watched and did you know what in the corner. He provided the substances. They all followed a pattern, and he dictated that pattern. Let me see. This is just all the like a few pages of them just rehashing what was talked about and shown at the trial. Okay, defendant's statutory arguments are not properly asserted under Rule 29. They say, among other reasons, Diddy's motion should be denied because his arguments, with the exception of one argument, are not actually even Rule 29 arguments. Like Rule 29 is only about sufficiency of the evidence presented at trial. Sufficiency of the evidence. You can't say, oh, Rule 29, I want to argue about whether or not a statute is constitutional. Like that has nothing to do with the sufficiency of the evidence presented at trial. Rule 29C, this is the part I wanted to read to y'all. Rule 29C is not, this is a quote, an open-ended opportunity to relitigate unfavorable rulings. It is not to contest jury instructions, nor is it to advance new legal theories. It is also not an opportunity to raise a challenge based upon sufficiency of the indictment that should have been raised before trial. So basically, those two things, that's the very, very high level overview of what is going to be argued about today in court on a substantive level. And then the judge did, thankfully, succinctly put it together. Judge Subramanian, I think it was, still him. Yep. He put this together. So let me pull this up for y'all. He put an order out of like exactly what he wanted to see them focusing on at trial. At oral arguments today. And this is the order. This is docket number 509. This was from just a few days ago, 3 days ago. This was the order. The judge said the parties have asked the court what issues they should focus on during today. You know, it says Thursdays, but that would be today now. Hearing on Diddy's post-trial motions. In addition to any other issues the parties wish to bring up, the court would like the parties to address the following questions. Okay, so what does the judge himself want, desire, hope, and order the parties to give him answers on? It's 4 things that the judge wants answers on. Number 1, in response to these 3 case law precedents, these are Musacchio, Blasek, and Dennis. The court's question is, does the government have any Supreme Court or Second Circuit case that has deemed a defendant's Rule 29 argument waived or forfeited in circumstances such as those presented in this case. Okay. So the government's arguing, we're on number one. I'm explaining this one to you. Why does the judge want to know this and what does it actually mean? He's saying, I need a precedent. I need to see if any judge has already decided this, because judges are really not supposed to like go against other judges. Precedent, especially in the same, or especially specifically in higher, at like if the higher court has already decided an issue, these judges are not supposed to go against it. So he kind of wants the go ahead from a higher court where they already decided something. He doesn't want to decide something for the first time. So he's asking for something from the feds. He says, can the feds give me any case law to support their argument that Diddy waived his Rule 29 rights? He forfeited the right to make these arguments because he did not bring it up sooner. That was one of the government's arguments. And the judge is like, all right, you say that, and I guess maybe it can make sense, but do you have any case law that supports that? The second thing that the judge wants to hear about from the parties, number two, if Diddy, were to prevail on his definition of the word prostitution, then would his conviction nevertheless stand on an aiding and abetting or willfully causing theory? Why or why not? Okay, so this is very, very complex. So they're arguing over what the definition of prostitution is. The government is saying this counts because somebody got flued out, somebody got paid, and sex was had. But Diddy and them are saying, yeah, but it wasn't had with us. It wasn't had with me. I was in the corner. I was making, that was an actor. He's like, I hired an actor. I could do that. I'm allowed to do that. So I didn't fly him out to enrich myself financially. That wasn't helping me. So the judge is saying, all right, so if we go with that definition of prostitution, would Diddy then have to have been just really aiding and abetting the transportation for prostitution? Because if Diddy's aiding and abetting, who does that mean actually committed the crime? That would be the people who engaged in the S Act. That's what the judge is saying. Like, it's a bunch of ifs, right? Like if, like he sets up a universe. He's like, if we're in the universe where I side with Diddy's definition of prostitution, would his conviction then rely on just the aiding and abetting or willfully causing the prostitution? Yes, no, why or why not? So that'll be complex. That'll be interesting to hear them argue about. The third issue that the judge wants to hear about and has indeed ordered the parties to address today at the hearing that's coming up in about 5 minutes, addressing the O'Brien factors. So there were factors in a precedential case, the O'Brien case. Why is the government's interest important? And the Mann Act's prohibitions no more than essential. What are the 1 to 2 best Supreme Court or Second Circuit cases supporting each side's position on these factors? So this right here, like basically like Diddy is saying this law is just being selectively enforced because the government doesn't really have any interest at all in stopping the production of amateur pornography. They're just like bullying me, Your Honor. And the judge is like, okay, I'm not deciding on that at this moment, but like, can the government actually argue against that point just so I can hear the arguments? 1 or 2 best Supreme Court cases. If you can't find one of those, give me some Second Circuit cases. These like the appeal level maybe, supporting each side's positions. And then the fourth thing that the judge wants to hear about is he says, Diddy argues that the record shows every time an escort traveled across state lines and had relations, he filmed it. Is that true? If it is true, does that change the First Amendment analysis? So this argument right here is the pornography thing, right? So he's addressing different things. These are like very specific parts. When you're making an argument, imagine it being kind of like a bridge, okay? And like you need pillars every so often to support a bridge. If you don't have pillars supporting a bridge or something, suspension, something supporting the bridge, it falls down. We'll call the argument the bridge. The judge is basically saying he has some issues with some of these pillars along the lines of the arguments, like along the way of making the argument. He's like, I'm getting hung up on the definition of prostitution If we go with Diddy's definition, how does it change the analysis of his conviction? What about the selective enforcement? I think this is the important or not important, no more than essential aspect. And then the final one is where Diddy's trying to say he was making corn. Diddy said every single time an escort traveled across state lines and had relations, he filmed it. So that means he had a First Amendment right to do the traffic. I mean, he was found not guilty on that. The transportation. He's like, I have First Amendment right to transport people to have relations on camera in front of me in a debauched way for 4 days in a row. And the government has no interest in stopping me. This is just so racist, is basically what Diddy is saying. I'm not buying it. I think he needs to shut up and take his 5 to 7. But let's go to Inner City Press to see if he has started tweeting. Actually, he did make a vlog. So let me show y'all the vlog he made about it. He said, I aim to start live tweeting around 11 a.m., which is in about 3 minutes. Right now, checking out the mad scene in front of the 500 Pearl Street Courthouse, and as much as I can, 40 Foley around the corner where Tekashi 6ix9ine is due. Also at 11 on new alleged violations of his, I guess, supervised probation. Here's the vlog. He did discuss the Diddy stuff here.
Dark skies and Diddy today. Yeah. Okay, here we are, Matthew Russell Lee, Inner City Press, here at the Southern District of New York Courthouse. Dark skies and Diddy today. The motion hearing on Diddy's long pending motions for acquittal or for a new trial. It begins at 11 a.m. and we're heading in. There have been people camped out since Tuesday in tents. Now, some have been saying he could be released today. It seems highly
Did y'all
unlikely
hear
to me.
that? Did y'all hear that? People have been camped out since Tuesday. In tents. Girl, I don't want to be anywhere that bad, girl. No. He's saying there's people out here saying that Diddy's going to get released today. That's highly unlikely. And this is this man's job, okay? He does this every single day he goes to the court. So I think he would have a lot better idea than me. So listen to what his analysis is on why he doesn't think Diddy's going to, even if the judge somehow sides with Diddy, it's very, very unlikely he's going to be walking out of the freaking place today. He still has to have his sentencing hearing next week, first of all. But anyway, listen to Matthew Russell Lee.
Intense. Now, some have been saying he could be released today. It seems highly unlikely to me. In the sense, mostly judges rarely rule, at least in SDNY, directly after the argument. And even if somehow acquittal.
He's saying, in his experience, judges really don't rule directly after an argument. Like the day of. They usually, take it under advisement and then they'll issue an order later. They're usually not going to rule that day. But then he goes on and even gives more reasons why he doesn't think this is going to get decided and settled today.
Full acquittal. Then they would ask for him to be held over for another trial. It's a whole rigmarole. In any event, we're going to be live tweeting it, and it should be interesting in part because there's a First Amendment argument, which is that if all of the encounters between the male entertainers, quote unquote, male escorts, dancers, and Cassie and Jane were in fact videotaped, is it covered by the First Amendment? So he's asked for the government to address that. So I don't know how long it's going to go, but we're going to do it. We're covering the UN at the same time, so it's a little tricky. Of course, we can't get into the UN, so we're doing it virtually. That's actually caught fire. I will say that this...
So that was pretty much the part about Diddy. So he did say he was going to start tweeting around 11 a.m. It is 11 a.m. local time there right now. So did he start? Yes. Okay, now, right on time. United States versus Sean Combs hearing on motion for acquittal or new trial. Inner City Press covered the trial in books. starting from indictment. Okay, so we got that up. While we are getting ramped up there, I want to show y'all another document that Teeny Garagos, Diddy's lawyer, did file just yesterday. It's like a half-page document. And I think she might have waited a little too late for this because I don't see that the judge actually granted this. But it says, please enclose, please find proposed order permitting Diddy to receive non-prison clothing at the MDC for his post-trial hearing and his sentencing. That's going to, the post-trial hearing is September 25th, 2025. The sentencing is this coming Friday, not this coming, but like next Friday, October 3rd. And here's the order. Diddy, inmate 37, blah, 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 will be permitted to receive non-prison clothing at the MDC to wear for his appearance on September 25th, 2025, and his sentencing on October 3rd. 3035, girl, that's in 1,000 years. Oh my God, they are sloppy. Teeny is sloppy. He is permitted to have 2 button-down shirts, 2 pairs of pants, 2 sweaters, and 1 pair of shoes without laces to wear to court. The judge doesn't appear to have actually signed this yet, so I don't know if he's going to be in prison clothes in there today or not. Maybe he will. I don't really know. But that was like very last minute for her to be out here like, oh, Your Honor, real quick, let me bring some clothes over there to Diddy tomorrow. Okay. So we're back at it again with Inner City Press. He hasn't tweeted anything else yet. So let me see if anyone else is live tweeting or live updating rather. It doesn't look like anyone's actually covering it live. Like, you know how we used to like have all the tabs up and stuff? So it seems like, sorry, I just saw something I wanted to. I saw something I want to make a video about later. It has nothing to do with this, so I got distracted. Okay. All right. So I guess Inner City Press for now is kind of like our only hope. There's no live trial. Let me see. Diddy. Let's just try Diddy live updates. I don't know if they just didn't send people into there to do that this time. We do have some articles I can read. Okay, again, this is the Twitter thread that we're going to be looking at. Inner City Press. Okay, now this one right here. He hasn't tweeted anything again. It may just not have started yet, but he did say we're here for the hearing on the motion for acquittal or a new trial. We'll live tweet this. And he's also going to live tweet the October 3rd sentencing. There's no gangs outside, or there are gangs outside. Thanks so much, James Steele, for the 20-pound super chat. Every little bit helps. Yes, it does. Thank you, thank you, thank you, thank you, thank you. Thank you, Sandra Ross, becoming a member. Thank you, Unnamed and Unindicted, for the $2 super chat. Good morning, cousins. Have a blessed day. Thank you, thank you. Shout out to Lauren. Thank you so much, Lauren518, for the $3 super sticker. Thank you, thank you. Even the media forgot about Diddy. I know. They not out there like they care that much. Shout out to Simply Monica in the chat. Shout out to Christy in the chat. Who else is in here? Shout out to Oklahoma Outlaw. Shout out to Green Eyes. Shout out to Sort of Truth. Haley said, I am far too excited for the hearing. I have missed the live cover. The Diddy Sorry, the coverage of Diddy trial BJ does. Hopefully the arguments are interesting and not hush hush. Indeed. Indeed. Maddie said, I am awake for the live, and it's after midnight in Australia. Been missing your Diddy coverage lately. Shout out to Kylie. Let's see if we have any updates here. Yes, 1 minute ago, 11:04 a.m., he said, Diddy is still in the holding cell. At the defense table is Alexandra Shapiro, who's now also representing one Alexander brother, Justin Baldoni, and Charlie Javis. Also at the table is Xavier Donaldson, Nicole Westmoreland, Brian Steele, and Mark Agnifilo. So the gang's all here. We got Alexandra Shapiro at the table, Xavier Donaldson, Nicole Westmoreland, Brian Steele. They flew in from Atlanta, I guess. And they also got there Mark Agnifilo. Teeny is not there. She must be getting pretty far along in her pregnancy. I mean, seriously, like I definitely think she's going to hell, but I think she needs a little maternity break. My God, let her go rest. Let her go rest. I cannot imagine worrying about all this stress and all this crap trying to grow a child. Okay. Here is another update 2 seconds ago, 11:06 a.m. Diddy is brought in a tan MDC jail uniform. Apparently, the proposed order for button-down shirts didn't get signed. And it's like that should have been last week. They should have submitted that. They said he's got a trial. He's got a sentencing hearing on October 3rd, 3035. I mean, they're just slipping over there at Teeny's office. So he's in the jail uniform. I would be so mad at Teeny if I was him. If I was paying her like $6,000 an hour or whatever the amount is, I would be like, girl, how are you going to let me come in here with the MDC uniform on? How? Nobody wanted to let me wear some clothes? That's what I would be saying. What am I paying you for? Sean Diddy Combs returning to court case. So this is an article we can read while we are waiting for some more updates from inside the courtroom. We are all caught up as of right now. This one came out this morning, just a couple hours ago. Diddy returning to court for hearing that could help determine how long he will stay in prison. Diddy is set to appear in court today. Hearing will take place that could help determine how long the Grammy-winning producer will remain in prison. Diddy has been detained since September 2024. The judge plans to listen to arguments from lawyers on points of law that could help him decide a sentence for Diddy, who was convicted on the institution-related charges back in July. Diddy will have been jailed for nearly 13 months when he's finally sentenced in October 3rd. That's next Friday. But his lawyers argued in court papers submitted this week that he should be sentenced to no more than 14 months in prison, with credit for good behavior. That would mean he would be released immediately. Prosecutors have suggested they believe he should spend at least several more years behind bars, although they haven't submitted their sentencing recommendations to the judge yet. The judge has signaled that he, too, is leaning toward a substantial amount of prison time. Twice, he refused to grant bail since the jury returned its verdict, citing Diddy's history of violence. Diddy was convicted of arranging interstate travel for people engaged in prostitution, 2 counts that carry a maximum sentence of 10 years each in prison, so up to 20 years. But I never expected him to spend 20 years in prison over this. I don't see it. Could have resulted, he was acquitted on the more severe racketeering, conspiracy, and ST charges that could have resulted in a lifetime sentence. Prosecutors said during the trial that Diddy had arranged and paid for sexual encounters between male S workers and his girlfriends, some of whom testified about being beaten, kicked, and choked by Diddy. The music mogul pleaded not guilty to all of the charges brought against him. Prosecutors said in the wake of the jury's guilty verdict that Diddy should receive at least 51 to 63 months in prison on the 2 convictions, which would equate to approximately 4 to 5 years. They later indicated that they would go for a longer sentence than even just the 4 to 5 years. Now, we do have a video here.
John Diddy Collins will be back in court for a pre-sentencing hearing. The proceedings will focus on several post-trial motions, including one that could release the music mogul almost immediately.
Aziza Schuler is live outside the courthouse in Manhattan with more on what we can expect. Aziza?
Good morning, Chris and Cindy. This morning's hearing will give both sides, Combs's lawyers as well as the prosecutors, a chance to weigh in on several questions that the judge will take into consideration when sentencing. That includes whether or not Combs's filming of sexual encounters raises First Amendment issues. The court also requested case law on how the Mann Act applies. That is a federal law that makes it a crime to transport someone across state lines for illegal sexual activity like prostitution. The 55-year-old music mogul was convicted in July of 2 counts related to prostitution after a federal jury found he arranged interstate travel for sex workers. He was acquitted of racket.
Pretty much what we, already read. Beautiful Messy Ball said, once you're convicted, you don't have the right to wear street clothes. You're property of the state. There is no presumption of innocence on jury bias. Nothing Miss Garagos can do. This is standard practice. Okay, interesting. Interesting. Him smiling in court don't sit right with me, Mom before said. Let's go back to Inner City Press and see if he has tweeted anything else. Oh. Yes. Okay. So the last tweet that we read from Inner City Press, just to remind you, 11:06 a.m. Diddy was brought in the MDC tan jail uniform. Apparently, the proposed order for button-down shirt didn't get signed. Diddy unloaded papers from a big file folder. He is seated between Jason Driscoll, who's like the little intern that works with Mark Agnifilo, and Brian Steele. So he's between Brian Steele and Jason Driscoll. I think Jason Driscoll works at Agnifilo's office. 9 seconds ago, here comes the judge. All rise. Let me get my little here. All rise. The clerk said appearances. Alexandra Shapiro said, with us is Mark Garagos. Oh, sorry. Excuse me. Teeny Garagos. Yeah. I mean, it probably gives you some indication of how much they're actually working with Teeny's daddy, Mark Garagos, who is bestianas with Harvey Levin over there at TMZ. I digress. But even this one can't even, it's so obvious that this girl, Teeny Garagos, who's like, I don't know, maybe a couple years older than me, so obvious that she's just a stand-in body double, basically just standing in for the real brains of the operation, which is her daddy, Mark Garagos, who also helped on jury selection and all that stuff. This is my opinion. But I do base the opinion on, for example, the public fact that Mark Garagos, Teeny Garagos' daddy, has helped to select the jurors. He was at the courthouse. I saw him with my own eyes pretty much the whole day that Diddy was found, whatever it was. The verdict came down. He was there the whole day. He was there. I saw him in the courtroom. I saw him in the court lunch cafeteria. So interesting. Everybody else clocked it too. They're laughing. Oh, we're here with Mark Garagos. Teeny, who didn't even know what freaking year it was. She was 1,000 years off, girl. Give Teeny a break. Okay, let that girl get off work for a few months. My God. Anyway, the judge says you don't have to take the full 15 minutes if you've already said everything you need to say. Please proceed. Okay, nothing else new here yet. Okay, let me just one more time. Another time, I want to see if anybody is covering it live here, like as far as like New York Times or CBS or the different, yeah, no, I mean, they're just not. Stop. These freaking ads, I swear. Okay, so we'll read a little bit of this article right here that was updated 8 minutes ago. Diddy due back in court for hearing ahead of sentencing next week. Lower Manhattan, Diddy back in Lower Manhattan courtroom this morning for the first time since his high stakes trial wrapped up with a split verdict. A judge will hear arguments from both the prosecution and his defense attorneys on points of law that will help him determine a sentence. Diddy was convicted of 2 of the 5 charges prosecutors had stacked against him that could have left him behind bars for the rest of his life. The split verdict left him acquitted on 3 of the charges, including racketeering conspiracy. However, a jury found him guilty on 2 prostitution-related charges. So here's the counts. I like how they gave the little chart. Count 1 was RICO, racketeering conspiracy, not guilty. Count 2 was ST by force, fraud, or coercion, not guilty. Count 3, transportation to engage in institution, guilty. That carries up to a maximum of 10 years. That's the Cassie one. Count 4 was ST by force, fraud, coercion of Jane. He was found not guilty. And then count 5, the second Mann Act violation, transportation of another human to engage in institution. That's Jane. He was found guilty. So the 2 right here, when red, that's guilty. And then the other 3 are not guilty. This is what's called a split verdict. Because you're not guilty on all counts. You're not guilty on all counts. Like it's a split outcome. Defense attorneys will ask the judge to overturn his conviction, arguing that the charge shouldn't apply to him because his intent was voyeurism, not profit. And the escorts traveled voluntarily. Well, that doesn't matter because he was not found guilty of force, fraud, or coercion. He's already acquitted of that he's not guilty. So the Mann Act violations do not require the Mann Act, the traveling, the stuff he was found guilty on. It doesn't require anything to do with force or fraud or coercion or any of that. So the fact that people traveled voluntarily literally has nothing to do with him being guilty or not, because it's already been accounted for. Prosecutors argue that there is more than sufficient basis to support the conviction. Diddy's been sitting in a Brooklyn jail for the past 13 months, stripped from the life he once knew. His lawyers say he should be free now, asking for a sentence of no more than 14 months in prison, including his time already served. Federal prosecutors say he should spend several more years behind bars. More than 70 letters were submitted to a federal judge from family, friends, and former employees asking for leniency ahead of Diddy's sentencing scheduled for next Friday. Today's hearing started at 11 a.m. So let's go back to Inner City Press and see if he has tweeted anything else. Okay. We have 2 more tweets. This is the government. The feds they get to go first. The prosecutors get to go first. Now, remember, this would probably be maybe like Maureen Comey doing this, but she got fired. And now she's done sued Donald Trump and the government and everybody for getting fired. So that's a whole side story going on, but I don't know who's talking. This is the prosecutor is starting by answering the judge's first question. The first question that the judge, or the first, he put those 4 things up on his order we just looked at a few minutes ago. The first question has to do with any case that the prosecutors can find that supports their argument that if a defendant doesn't bring up a Rule 29 argument at a certain time, then they waive it or they can't bring it up. The feds have said that. And the judge said, all right, fine. Give me some cases where that happened before. So that is where this prosecutor is starting. She says, we point you to the United States versus Kelly in the Second Circuit. That's this year this case came out, 2025, which stands for the proposition that Diddy's Rule 29 arguments had to have been raised before the trial. He didn't raise them before the trial, and so they are waived. He cannot now say, anything about sufficiency of the evidence. The judge says, okay, let's separate. The judge talks immediately. He's like, hold on. Hold on. Let's separate out the jury instructions. You're saying that this defendant's constitutional arguments should have been made at the Rule 12 stage? So before the trial. And the prosecutor said, yes, Your Honor, that is exactly what I'm saying. That is correct. Yes. And the judge says, well, Diddy is making an as-applied argument. How could they have done that before the trial? Because it was actually applied in a certain way. They can do that on Rule 29. Let me see if there's any more context here. She said, no, Your Honor, the prosecutor, Your Honor, I want to push back on their reading of the case. Like, I want to disagree with them, basically. In Dennis, this is one of the cases that the judge mentions in one of those questions. I think it was the fourth question or the third, but I want to push back on their reading of the cases. In Dennis, the defendant was arguing that he couldn't be tried without infringing on the First Amendment. The parties agreed. It was only about sufficiency. The judge said, but the court went right past the waiver. Okay, so again, the judge is trying to really hone in on a micro portion, a microscopic portion of the grander scheme of the argument, which is, can Diddy even bring this argument up, right? Like the judge, it's this Rule 29 argument. Diddy is relying on the Rule 29 argument to pretty much try to get a new trial and overturn his trial, the guilty verdicts. He's relying on Rule 29. Let me read what is Rule 29 just so I remember and y'all know or remember. Maybe y'all already know. Yeah, motion for a judgment of acquittal. So this is the rule we're talking about, Rule 29. It is the rule that allows somebody to do what Diddy is doing before submission to the jury. After the government closes its evidence, or after the close of all evidence, the court on the defendant's motion must enter a judgment of acquittal of any offense with the evidence is insufficient to sustain a conviction. Okay. So the Rule 29 argument is like the trial has passed. Remember when it was like, oh, now Diddy's trying to get an acquittal. And it was like before the jury even returned their verdict, and it was like, we got to see what the jury does first, and then all that, and then the judge, and now he's trying to renew the motion or whatever. So in this particular case, Diddy did do that. But what the government is arguing is that there's some arguments that he's saying, oh yeah, I'm just going to throw the whole kitchen sink into this motion for acquittal, when really the motion for acquittal is specifically supposed to say, look, Your Honor, we just went through a whole trial. The prosecutors did not put up enough evidence to show that Diddy committed any of these crimes. And we just need an acquittal straight from you. Take it out of the jury's hands and you take it into your hands. First of all, that's already just such a hard thing to win. A judge is almost never going to take something out of the hands of a jury. Yeah. Shout out to Monica in the chat. Good job moderating. So that's what's being argued here. And pretty much Diddy is putting a whole bunch of arguments in this one basket of like, oh, I want to put this in the motion for acquittal. But like the government is basically saying, yeah, sure. Okay, fine. Most of his arguments, you can't, it has nothing to do with the sufficiency of the evidence. It's just Diddy's not happy that the jury found him guilty on something. Moving right along. The evidence was clearly sufficient because the jury found him guilty on 2 things and not guilty on 3 things. The court can reserve the decision on the motion. Proceed to the trial where the motion is made before the close of all the evidence, submit the case to the jury, and then the judge can decide on the motion before the jury returns their verdict. He can also decide after the jury returned their verdict. If the court reserves the decision, it must decide the motion on the basis of the evidence at the time the ruling was reserved. Okay, so you can't put new evidence in. All right. So after a jury verdict or discharge, which is where we are now, this rule would apply here. A defendant may move for judgment of acquittal within 14 days after the guilty verdict. If the jury has returned a guilty verdict, which is the case here, the court may set aside the verdict and enter an acquittal. If the jury has failed to return a verdict, the court may enter an acquittal. Okay, so in this case, the jury did return a guilty verdict on the 2 Mann Act charges. That's what he's trying to get the acquittal on. The judge can set aside. He has the authority, has the discretion to do so. And so that's why he's asking them in court right now, give me a case where someone already did this before, because I don't want to be the first person making this decision. Motion for a new trial. Okay, so conditional ruling on a motion for a new trial. So he also has motioned for a new trial in the alternative to the acquittal. If the court enters a judgment of acquittal after he's found guilty, so if the judge would enter an order of acquittal today, the court must also conditionally determine whether any motion for a new trial should be granted if the judgment of acquittal is later vacated or reversed. The court's order conditionally granting a motion for a new trial does not affect the finality of the judgment. Okay, they can appeal it. Okay, so the government's basically just saying you can't just throw any and everything that you just didn't like about the trial into this. You really don't have any leg to stand on here. We do have a new tweet. The judge is like, did Diddy waive his right to bring something up because he didn't bring it up before Rule 29? Did he have to bring these constitutional arguments, this amateur pornography stuff? Shouldn't he have had to bring that up in the first instance, like before right now? Shouldn't he have had to bring that up? Like he never made this First Amendment, I was making corn argument until now. Somebody give me a case. Did he waive his right to bring it up by never bringing it up before? The judge wants a precedential case. So the judge looks over to Diddy's lawyer, Alexandra Shapiro, and says, Miss Shapiro, can you address these arguments? She said, the Dennis case is on point. The court made clear that statutory construction arguments can be raised under Rule 29. Also, the Lopez case. I argued the Lopez case, Your Honor. Okay, again, y'all, this is only the first step. The judge then has the authority to move forward. Like, let's say Diddy didn't waive it and he didn't waive his right for these arguments to be considered, and the judge considers the arguments. The judge can still say, I disagree with all Diddy's arguments. So this is just getting past that first step. The court made clear in the Dennis case, statutory construction arguments. So this is the Mann Act being unconstitutional. The statute is too vague. The definition of institution is too vague. The way that you would read the statute, does what Diddy did actually qualify and count as a commercial act, et cetera, et cetera. These are all things Diddy's lawyers are arguing. These are all things that can absolutely be brought in a Rule 29 motion for an acquittal or a new trial, which is what we did, and that's allowed. Again, y'all, that doesn't mean that he's going to get granted the motion. We're just trying to start out to see if the judge can even consider it. He might say no. I mean, like it's kind of like jurisdiction or whatever. You have a certain time to bring it up. When you don't bring it up, I can't address it. And again, y'all, the whole thing was filed as a Rule 29 motion for an acquittal. So each and every little specific thing that Diddy brought up needs to actually qualify. So some of this stuff might be able to be considered and some might not. Maybe all of it could be considered, maybe not. We'll have to see as this oral argument goes forward. Okay. So he does offer an update a minute ago on the Tekashi 6ix9ine case. The hearing is at the same time as Diddy. Southern District of New York prosecutors say Tekashi 6ix9ine is seen on video briefly assaulting a guy at a West Palm Beach mall who taunted him for being a cooperator in the 9 Trey Bloods case. Very interesting. Let me pull up the article too so we can have it on hand of all those letters because Diddy Diddy submitted like 60 something letters, character character reference letters in a sentencing memorandum. So I'll pull that up so we can kind of look at that as we're waiting for new tweets to roll in from Inner City Press. They're kind of in the weeds right now, I will say. I mean, it's kind of hard to understand because what they are arguing about is kind of like very specific technicalities. It's like, under the federal rules of procedure, was Diddy even allowed to bring these things up or did he waive the arguments? Could he even bring them all up? And now it's like all the arguments he made at all were brought up under Rule 29. I mean, one of them was like a constitutional issue, like First Amendment. So I don't know if that's Rule 29 or not, but like I think Rule 29, because it allows you to file the motion for acquittal, everything applies to this. Again, kind of confusing. We do have another tweet 16 seconds ago from the judge. The judge says, or from Inner City Press, and it's the judge saying, let's put the financial motive aside. Okay, let's forget about this whole commercial purpose thing. Let's put a pin in that. Why wouldn't Diddy be liable under a willfully causing theory? Cassie or Jane furnished the payment for the escorts, but Diddy still had the relevant intent, didn't he? So this is the judge saying, all right, look, let's say Diddy's definition of stitution is correct. Let's just say. Let's say he wasn't making any money at all, okay? In a case where Cassie and, or Jane, but we'll just go with Cassie for now. In a case where Cassie called, arranged the meeting, arranged the travel, handed the money over, but Diddy was still in the room. Diddy was still sitting there filming. Diddy was still sitting there doing, whatever he was doing to his own self. Wouldn't Diddy still be willfully causing that? Like, okay, like let's say you threaten somebody and you say, if you don't go over there and unalive, whatever. Let's not do unalive. That's like pretty serious. Let's say there's like a special endangered tree. Okay. And somebody tells person A says, hey, person B, go over there and cut down that endangered tree. Even though it's a crime, go cut it down. And person B is like, I ain't going to cut that tree down. What are you talking about? And person A is like, well, if you don't do it, then I'm going to leak your nudes. And then the person B is like, well, I mean, I guess, okay, fine. And it goes cut the tree down. Didn't person A willfully cause the tree to be cut down? Didn't person A say, if you don't do it, I'm going to release your tapes. And if you don't do it, I'm going to release the tapes. So you better do it. Isn't that a willfully causing? So along that same vein, the judge is saying, well, okay, fine. Maybe Diddy didn't make money. Maybe he didn't even engage in the act with the commercial S worker. How did he not willfully cause Cassie and Jane, at least in some of these instances, to do the crime? Like, even if he didn't do the commercial gain, somebody commercially gained. The S worker commercially gained because you paid him. So how is it not still you willfully causing or aiding and abetting this crime? And the judge, I mean, seems like the phrasing of that question is like he's already leaning in that direction. Let's see what Diddy's lawyer tries to wriggle out, though. She said, no, he didn't willfully cause that, Your Honor. Many states find that stitution is only when A pays B for relations with A. So there's no third party, involvement allowed. Here, Diddy's lawyer says, the feds, the government, they're trying to get around that. But the cases where people watch other people having relations, that doesn't count as the legal definition of stitution. The actus reus in the Mann Act is transportation. Okay, so the relevant act is not the stitution. The relevant act here is the fact that somebody was transported. The transportation, that is the relevant action that you have to show. She says commercial voyeurism is not stitution. Girl, a number of states say there's the Paulino case in New York. There's also a Georgia case, which has nothing to do with anything, but I'm sure it's because Brian Steele knows about it. He's the Georgia lawyer. The government had alleged that a private residence in this Georgia case had been used for stitution, but the court said no. Voyeurism does not equal stitution. Now, this is just in some jurisdictions. She said, Alexandra Shapiro said there is a state court case, which doesn't apply here because this is federal court. Well, it could apply. It could apply. But the same way that the feds are really not able to come up, the government is really not able to come up with a case where somebody was specific on point to the facts of this case. Neither is Diddy's side. Nobody can come up with a case that's exactly on point here. Diddy's side came up with one from Georgia, came up with a state case from New York, but we're talking about a federal court in New York right now, the Southern District. So is it stitution to do what Diddy did is kind of like the question. Diddy's lawyer said the statute originally had a section about debauchery. This is so cool because this was my favorite class in law school. I set the curve in the class. I think I made the highest grade in the class. I might have made the only A in the class. And it's because it's like a linguistics class. It's called the Canons of Statutory Construction. I think the short name for it at Penn Law, if you're over there, is legislation. But like they basically get in the weeds like this. But like most people who don't have like autism brain like I do would absolutely want to claw their eyeballs out trying to get this deep in the weeds. But like this is all these different canons of constitutional and statutory construction where like whenever you're a judge and you're trying to figure out how to apply a law to a certain situation, you kind of have to reverse engineer like what was in the legislative branch's mind whenever they were writing this law and going through all the legislation of passing it. So this is just one of the things. There's so many things. There's a very long list of things, and you're supposed to go in a certain order of like most important thing to consider to least important thing to consider. And that's kind of what they're doing here. I think that they might be going in an order that's more applicable to this specific case than like, if they were just doing fact pattern recognition. But Diddy's lawyer says originally the statute, the Mann Act, had a section about debauchery, which maybe could have included voyeurism. We don't know. But they took that section out, Your Honor. The Supreme Court reversed a Seventh Circuit holding that had affirmed a conviction where the defendant did not have a commercial motive. So already the Supreme Court has decided on something kind of like this, but it's not exactly on point. There was a Seventh Circuit, and this is not the Seventh Circuit. I think, what is New York? The Second Circuit? So it's not the Second Circuit. That's not the Seventh Circuit. So again, it's not necessarily binding. However, the Supreme Court did reverse a Seventh Circuit holding. Okay, so in the Seventh Circuit, they had a case, and in that case, they held that somebody could be convicted where the defendant did not have a commercial motive. He did not have a commercial motive. So this is another thing. Like, does it even count as stitution? We're really getting very in the weeds. Number one, is it even stitution at all? Did his lawyer say no? Because voyeurism is what he was doing. That is not stitution. Number two, he did not have a commercial intent, which is required under the law. I think he did. He intended to pay the S worker, and he knew he was going to have to pay the S worker. He had no problem paying the S worker or causing the S worker to be paid. But again, this is what these lawyers do. This is why they make so much money, because they will get so deep down into the weeds and confuse somebody where it's like, I guess, I don't know, the legislators might need to speak. They might need to add debauchery back in there. But the Supreme Court has already reversed a previous conviction where the defendant did not have a commercial motive. So did Diddy or did he not have a commercial motive? That's another question. we have another new tweet. Diddy's lawyer said traveling interstate for a woman being a mistress or a concubine, the judge cuts her off. Wait, hold on. The Cleveland case said polygamy met the immoral purposes test. Okay, so there's a test within this thing called immoral purposes. I don't know what the immoral purposes test is. I didn't read the 120 pages of arguments. So for the purposes of this live stream, we're just gonna have to do our best to reason through it. But she's like traveling interstate for a woman being a mistress or a concubine. So they're saying the quiet part out loud. Okay. Sean P. Diddy Puff Daddy Combs' lawyer is in court right now, moments ago, saying that Jane and Cassie were concubines. Okay. I mean, like that, I don't know. I wasn't in there. I don't have the transcript. I'm reading tweets, but that's what it appears to me based on reading these tweets, which I found to be fairly reliable so far. Pretty reliable. The judge said, wait, you're citing that Cleveland case. That Cleveland case said polygamy is an immoral purpose. Okay. Diddy's lawyer said, respectfully, I disagree. There was a late 19th century case about immigration. She's like, no. I don't like that case you're bringing up, Your Honor. Let's just move on. I disagree with that one. Let's go to a different case. Let's talk about a different one. Hold on. I need to block some. God, I forgot how much I had to do this. I forgot I had to do this. So just like anything else with or how much I had to do this. Just like anything else that we always talk about on this channel, things have very specific definitions. And I think a lot of people get very, very in their feelings and like get their egos involved whenever they want to argue about the definition of something. Things have definitions. Okay. So in the same way that, you can't just go around saying like, oh, Diddy blackmailed or Diddy extorted without actually somebody finding that happened. There's certain things that have to be met, like remember in the Emmanuel Harrow case where they were saying the guy had confessed, but technically he hadn't confessed. Maybe he had admitted it. Maybe he had told somebody else. Like there's certain things, statutory things have to be met for confession. The same thing goes for this immorality, this immoral purpose. There are certain things that are, this is actually super complex and complicated. Like this is one of the more complex, complicated things we've talked about throughout the entirety of the Diddy case, because this stuff relies and rests on theoretical legal propositions that are just kind of like elusive, evasive, and blurry. So when you get down into the weeds like this, a lot of times you run into certain moral or philosophical questions, which we really haven't been seeing addressed as much in the Diddy case until this aspect or this, this stage of the post-trial. But there's a lot of kind of complex legal, like theoretical constitutional legal arguments going on. So in general, we have life, liberty, pursuit of happiness. In general, starting point default, citizens of the United States of America have the right to pretty much do whatever we want. Okay. Except, right? And then there's this whole thing called the law that defines what you can definitely not do. Right. So within the law, why do we have laws? I mean, this is one of the things they ask you on the first day of law. Why do we have laws? Why do we have laws? Who made them up? Did they get handed down from God to Moses on the mountain and he came down with commandments? I mean, maybe those 10, and some of those ended up making it into the law. But how and why do we have laws? It is a measure of our society's moral and ethical beliefs. Now, is it everyone in the whole society believes and it morally aligns with every law? Of course not. Of course not. However, laws are things that are generally based on morality. Sometimes they're based on efficiency, like, waiting at a stop sign or, stuff like that. Like, it's not like, a moral law, but like laws about institution often have to do with moral issues. Now, a lot of ink has been spilled to deny that and to act like that's not true. But let's all be honest. Thou shalt not kill is a law in every single, every single state that it's a law in, because it's just generally not the right thing to do to kill somebody. Just generally not the right thing to do. Now, legal scholars will argue, no. It's so that people can feel safe in the society and be productive and know that their life isn't going to be in danger. And if somebody unalives them, then somebody will pay the consequence and there will be some retributive justice. Okay, maybe, girl, maybe. Okay, I don't think so. I think most of these laws are based on morality. Let's stop trying to call it something it's not. But I think it's okay. We should all have some moral agreements. I mean, we should have something that we agree on, like don't, traffic little girls, don't kill anybody, certain things like that. So really, they're kind of down in the weeds arguing about this right now. And frankly, in my opinion, Judge R.N. Subramanian's courtroom is just not the place to have this argument. Like, this argument needs to be being had somewhere else. But in particular, it should have been being had way before the trial happened. That's my opinion. That's the government's opinion. But let's see what they argue. All this stuff is my opinion, by the way. I'm not an expert on any of this. Except, I did make that A in that class that time, but girl, that was years and years ago. Okay, we do have a new tweet. So let me read the most recent tweet that we did read before I get into the brand new tweet. Did Diddy's attorney just call Cassie and Jane concubines out loud? Yes, Diddy Docket. I heard that. I read it. I don't know. I wasn't in there. Okay, so traveling interstate. So this is Diddy's lawyer. Again, I'm just repeating the last tweet just so you can remember where we were. She says, traveling interstate for a woman being a mistress or a concubine, the judge cuts her off. Wait, the Cleveland case, the judge said polygamy met the immoral purposes test. Meaning that actually does rise to the level that allows states to prohibit it. Because, there has been polygamy lawsuits, right? Like, people have said they have a First Amendment right to marry 5 women. And the government has successfully argued all the way up to the Supreme Court level, you don't have the right to marry a lot of people all at once. You have the right to marry one person at once, period. And the reason is because the state, and now look, I don't give a shit. Excuse me, my language. I don't give a crap if somebody wants to marry 5 people. I don't. It don't bother me. It don't affect me. I'm not doing it. But it doesn't bother me or affect me at all. However, I'm just going to tell you what the state and the government has argued and what the Supreme Court has said. This is not me saying this is my opinion, but the Supreme Court has said that actually the state also has a right in marriages. The state has a right, each individual state, but also the government, the federal government, has the right to encourage, support, and condone a traditional family model. The traditional family model has evolved over the years. It used to be this is what you remember Loving versus Virginia, 65 and a half years ago or whatever. I wouldn't have been able to get married to the person that I am engaged to right now in certain states. Loving versus Virginia had one such law where Black people, white people could not get married. No, you cannot. So this couple went and got married in DC or something, Maryland or something. And then they came back to Virginia as a married couple, but their marriage wasn't going to be recognized in Virginia. It was a white man and Black woman. I don't exactly remember if it was that way or the other way around, but it was an interracial couple, and it was illegal for them to be married in Virginia. This was later overturned by the Supreme Court as an unconstitutional law. However, when it was making its way up through the Supreme Court to the Supreme Court, and when it finally arrived at the Supreme Court still had to do a certain analysis of the Loving versus Virginia. It had to be a scale weighing interests on each side of the scale. On one side of the scale is the interest of life, liberty, and the pursuit of happiness of the individuals who want to get married, the couple. But on the other side of the scale was the government's interest in a sort of traditional looking family unit. So the Supreme Court has decided that to base whether somebody can get married to somebody else on race is just not constitutional, because it's a suspect class to prohibit somebody from doing something based on their race. But the Supreme Court has declared that the state or the government has an interest in not allowing you to marry more. So you can marry somebody Black, white, somebody from another country. You can marry somebody different race, national origin, ethnicity than you under the Supreme Court. Again, this is not my opinion. I'm just telling you what I understand the Supreme Court to have decided in a very cursory overview way. The government has rights over how it can administer its stuff as well. And this is where the federalism concern comes in. Okay, this is all extremely complex. I'm not an expert. I'm probably saying some stuff wrong, but the purpose of this is just to give you an idea of what area of law we're kind of in here, where the government, the Supreme Court has already said polygamy cannot happen because we have an interest in a certain type of family unit being perpetuated out here in the world. Again, Obergefell. This was a case with the gay marriage back in 2014 or so. Whenever all of a sudden gay marriage was like, oh my God, I can't get married in my state if I'm gay. But then all of a sudden, boom, out of nowhere, like not out of nowhere. I mean, there were like a century of human rights, protests and stuff. I'm not trying to be glib. I'm not trying to be dismissive. I'm just trying to get to the high points here. According to the Supreme Court, again, y'all can disagree with this, but according to the Supreme Court, you cannot discriminate on allowing someone to marry somebody or not based on their gender, their sex. But you can say you can only have one same gender wife. You could only have one interracial wife, different race than you or whatever. So here the judge is like, well, this polygamy test has already been passed or whatever. And Alexandra Shapiro is like, no. Let's not talk about Cleveland. No. Let's talk about this late 19th century case instead about immigration. All of the federal constitutional law that developed around privacy, sexual relations. So she's making now a privacy argument. So not only like a First Amendment argument, there's also a privacy argument. They're just throwing it all here at the wall. And then the judge cuts her off and looks over to the prosecutor and says, Miss Foster, she said, this case is different. The case that Diddy's lawyer is talking about, Your Honor, is a person in a booth watching people have relations. Diddy is challenging the term stitution. Here, in this case, Your Honor, this is the feds talking. The woman helped arrange the transportation of the escorts. So, for the defendant, it's still at the very least aiding and abetting. The judge goes, okay, talking to the prosecutor. So you're saying he had the intent, he paid the money, he had the relations, and that is the willfully caused? Before she can even answer, here comes Diddy's lawyer. Can I respond? Can I get in here? Can I respond to that, Your Honor? Like, no one's even freaking talking to you. You just had your turn. He said, I'll give you time at closing. Looks back over to Christy Slavic. Miss Slavic? She said the record does not show that every time an escort traveled and had relations, that the relations was filmed. First of all, it does not show that. They only say that he, quote, routinely filmed. He frequently filmed freak-offs or hotel nights, but not all the time, Your Honor. The explicit videos charts show that there was travel for relations, but sometimes there were no videos recovered of those encounters. We can pull up the exhibits if you want, Your Honor. The judge said, okay, but you also argue that even if they were all filmed, it still wouldn't matter. You said that in your briefings. So can you get into that argument? Okay, so he's flying. Again, he probably already has his mind made up, but he does have some specific questions, these pillars along the way of building the bridge where he's like, hold on, we got some cracks in this pillar. So he seems to be satisfied with the aiding and abetting or willfully causing theory. Basically, somebody set it up and Diddy knew about it. He encouraged it. He participated in it. So even if he wasn't having the relations and even if he wasn't handing over the money, he probably was aiding and abetting. But anyway, moving on, the judge goes to the next question and says, now you also talk about, let's say he did film every single one, right? Like every single encounter was filmed. You say, even if that's true, that his First Amendment argument doesn't work. Remember, he said, I have a First Amendment right to produce amateur pornography or whatever. And the government basically said, no, you don't. No, you don't. Even if you recorded every single one of these things, you don't have the right to do this conduct. The judge said, okay, so you argue that even if all the SUL encounters were in fact filmed, it still wouldn't matter. Can you talk more about that? The prosecutor said, right, yes. She said, the Mann Act criminalizes travel for prostitution, not filming relations. The test for symbolic speech. Okay, so this is the First Amendment, symbolic speech. So the First Amendment protects so-called actual speech and symbolic speech. Burning an American flag is usually the example they use in classrooms. It's offensive to some people. It hurts people's feelings in a way. However, because it is an act of protest, it is an act, again, y'all, don't shoot the messenger, okay? Obviously, I love the American flag. I ain't burning it, okay? But it has been adjudicated time and time and time and time again. Political speech acts, even if it's not actually speaking words, it's called symbolic speech. Burning a flag, putting tape over your mouth and standing there at a protest is still speech, even if your voice box isn't making a word. Under the First Amendment, you have certain rights under the First Amendment that count as free speech. That even if it's not you speaking, it's symbolic speech. So here, an argument has been made. The test for symbolic speech is whether there is an intent to convey a meaning. The transportation conveys no message, Your Honor. This was private stuff. There is no symbolic speech. There's no protected speech here. What he did was just illegal conduct. That's what's being argued by the government. He's not flag burning. He wasn't intending to convey any message, political or otherwise. He was doing SUL debauchery. That's what's being argued. We have a couple more tweets. Yeah. She says, Your Honor, in the O'Brien case, this is still the feds, the prosecutor talking. In the O'Brien case, the protected symbolic speech was the burning of draft cards. See, it's like burning stuff. Here, transportation to engage in an S act is not symbolic speech. The judge said, okay, well, if a movie producer is making pornographic films, the judge is asking this question, are you saying the First Amendment is not implicated? Because that's another one that has been decided. Again, whether you like it or not, whether you agree with it or not, making a pornography film is a protected speech under the First Amendment for whatever reason. It just is. It's just how it is. It could maybe go back to the Supreme Court and get overturned one day, but that's just where it stands today. I will refrain from getting into my personal opinions and beliefs and my moral and ethical positions, but I'm just telling you what has been well settled and what confines this particular judge definitely has to work within and under. He says, if a movie producer is making a pornographic film, isn't the First Amendment implicated? But the assistant U.S. attorney said, that's a closer call than this, Your Honor. That's different. Because a pornographic film is, I'm assuming, because a pornographic film is meant for production and consumption by an audience. Private storing of stuff is not like an expression of free speech under the protection of the First Amendment. Like free speech really is originally like OG first thing ever, was out here for was so we could criticize the government. That's what it really was. It was so we could criticize the government without being put in jail, without being unalived, without having to pay more taxes. And little by little by little, it has grown from that, in the last 200 something years. But making a private debauchery film for your own private collection, I don't know that that's necessarily the same thing as like needing to be protected, like criticizing the government publicly or privately. I'm assuming that, she's basing her arguments on that. She does that. We do have another tweet here, 2 more tweets. The assistant U.S. attorney said in the other case cited, though, the producer said when they transported, we'll be filming a movie. Here, Diddy only intended the individuals to engage in prostitution. The defendant here was not an amateur corn producer. Like, let's just call it what it is. The judge said, okay. Well, if we get to O'Brien, what's the important governmental interest? Remember, I told y'all about the government interest in the traditional family unit, right? They do have a legally protected, qualified right, the state, right? The government, the people who make the laws that they want to impose over us. They have certain rights to certain things, right? Like law and order and, peace or whatever. These are all legal things. Like, I know that, like, for people who aren't used to hearing this, talked about this in such a theoretical way, your knee-jerk reaction may be to just be like, what's the state have right for? I hear you. I'm just trying to help explain what's actually going on in this courtroom so you can have any idea what they're talking about. I'm really not trying to get into should the state have a right, should the state not have a right. Okay, that's not my point. I'm not even necessarily advocating. I'm just telling you the legal reality of where we live. Okay. So, or where I live. I know some of y'all are from out of the country and y'all are not here right now, or, not from here, whatever, but this is my understanding. And I'm just trying to help y'all understand what's going on in this hearing. So when the state might have a right to certain things, like the efficient administration of justice or whatever, the traditional family or whatever, but they don't have the right to infringe too far on somebody else's rights. So there's always this balancing that has to go back, and it always happens in courts. So the judge is saying, all right, so let's say I get all the way to this O'Brien case, which I might just decide none of this stuff. Remember, the first thing we talked about at all was like, he might even just say, okay, well, I can't decide any of this stuff. You waived your right to bring it up. He could still decide that. But he's going down these arguments because both sides did like, and if you don't agree with us on that, then in the alternative, blah, 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 blah. And in the alternative, da, 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 da. So here, the judge is saying, what's the state's important interest that they have in stopping this specific type of behavior where somebody pays somebody for their flight and travel? He's sitting in the corner doing what with a camera, and it goes on for 3 days and there's drugs involved. What is the government's important interest of stopping this? The feds say, well, I'm going to tell you, we have a substantial interest in regulating prostitution. The court declined to apply O'Brien because the act had nothing to do with speech. So she cites this case, a very old case. I mean, it's not very old, but they're citing cases from 2025 right now. So to cite something all the way back to 1986, this is like a long established case. She said 478 U.S. 697, I think this is the Supreme Court, 1986, declined to apply O'Brien because the act of having relations had nothing to do with speech. Again, speech as defined under the law through hundreds of years of jurisprudence. We have a few more tweets from the oral arguments. She said Justice Souter in dissent said he would have applied O'Brien, but he even agreed that regulating prostitution is an important government interest. On laws against nude dancing, the court found secondary impacts to be important. So there could be laws in certain towns where we can't, this is a place where you can't have a topless, a booby bar or whatever. So these are like the lewd, debaucherous, obscene. This is like the lewd and obscenity area of case law, where what is lewd, what is First Amendment, what is obscene, what is not. She says, so the assistant U.S. attorney said, on laws against nude dancing, the court found that you could even look at secondary impacts on the community, secondary impacts on families, secondary impacts on people around. So this is well settled, Your Honor. There are reasons to regulate prostitution. See erotic service provider circa 2018 case. This was about a California prostitution law. It's about preventing violence against women. It's about health. All 50 states regulate constitution to some degree, Your Honor. Every state in this great country has some level of regulation on stitution. So since this is stitution, you are within your right to regulate it. This isn't unconstitutional. Diddy is delusional. That's basically what the government is arguing. She said the federal interest kicks in for transportation because you're transporting her across state lines or internationally. Not only her, but like the actual entertainer or S worker. She said the Barnes case, Your Honor, found that requiring pasties for dancing was okay. So requiring, people at the topless bar to wear the stickers on the what, that was allowed because the state had an interest in interstate transportation of people, et cetera, et cetera. The judge said, okay, I've heard enough from you. He turns back to Diddy's lawyers. Alexandra Shapiro is the one making these arguments right now, and says, Ms. Shapiro, can we move to the First Amendment argument? Now remember, what is the First Amendment argument? The First Amendment argument is the one where Diddy said he had the First Amendment right to make this corn. Basically, he's like, no, I was doing amateur corn. So forget about whether or not he waived his right to make that argument. They already discussed that. He just now wants Diddy's lawyer to talk about Diddy's First Amendment right. First Amendment right to do this freak offs. Okay. A First Amendment freak off right. And first thing out of Diddy's lawyer's mouth is, it was filmed the majority of the time. Okay, but you said every single time. See how they switched the goalpost? At first it was filmed every single time he did that. Every single time it was filmed. And then the assistant U.S. attorney got up there and said, that is just not true. It was not filmed every single time. I don't know what this man is talking about. What this woman is talking about. It was not filmed every single time. So she gets back up. Diddy's lawyer's like, okay, fine. Most of the time. Most of the time it was filmed. Fine. She says, just because the footage wasn't found doesn't matter. The U.S. has ignored our The U.S. has ignored our 2D First Amendment argument that he was a consumer of amateur pornography. As to being a producer, amateur porn is protected by the First Amendment. At trial, they emphasized that it was choreographed, that there was role playing, there was wigs, it was filmed. So that's covered by the First Amendment. But Mr. Combs also had a right as a consumer of amateur pornography. This needs to be overturned, okay? You have a First Amendment right to do freak-offs? No. I mean, freak-offs in your own house, I actually think you probably do have a First Amendment right. But to film it without even asking people if you could film, which is what was told at court, okay. So this does make me wonder, was Diddy doing all this wigs and this thing and that thing, like in part because he knew that one day if he ever got caught, he could just say that it was, I was making corn. I was making cornography. And so, yeah, I mean, obviously I'm not guilty because I was making pornography. This First Amendment right. It's First Amendment right to do that. I want to get to these letters. At least have them up. So if y'all want to, so if we want to read them in our meantime, Janice Combs's is the first one up. Girl, what are they saying on here? I didn't even read this part because I just downloaded it. It's like a 380-page document, but I was just scrolling trying to find Janice Combs's letter, and it's like Diddy's behavior has markedly improved while in treatment. Under evaluation of the MDC, Diddy stopped using opiates by the time of his arrest. He was still abusing other substances. In the Park Hyatt Hotel at his arrest, agents recovered a pink powdered substance that tested positive for MDMA and ketamine. When Diddy was remanded to MDC, he tested positive for redacted. As disclosed to the BOP upon his incarceration, Diddy was honest that he redacted to help alleviate Diddy's withdrawal symptoms relating to his discontinuing redacted. The psychology department at the MDC has assisted with Diddy's addiction recovery since his first week in jail, provided him with a workbook on substance called My Recovery Song. Throughout his incarceration, he has expressed a desire not to take substances. With the help of the medical unit, he has resisted the urges to use, even though contraband drugs are readily available in the MDC. Diddy has been in treatment with the psychology department at the prison and also been examined extensively since March by Dr. Richard Kruger and Dr. Meg Kaplan regarding how he responds to situations that trigger him. So like anger management type stuff. Starting almost immediately after his incarceration, his attending psychologist created a safety plan with Diddy and helped him redacted. Diddy worked with a psychologist to redacted. As one would imagine, this was not always easy for him since he was suffering with depression and acclimating to his new surroundings at MDC. There were days when Diddy was unable to get out of his bed or even walk to the psychology department. Yeah, well, I heard Cassie and Jane Doe say the same thing, but he don't care about that. He continued with his work at MDC and even sought out evaluations from Dr. Kruger and Kaplan. Redacted. When Dr. Kaplan began evaluating him, she redacted to help him identify redacted. Diddy worked through the workbooks on days he was not being evaluated and redacted. During the months of evaluation by Dr. Kaplan, Diddy worked diligently to address issues of redacted. Dr. Kaplan's evaluating work included the following identification of triggers. That's interesting. Okay, so this is funny. I mean, it's not funny. It's actually kind of sad, but I didn't know any of this existed. Jamil Spencer has seen Mr. Combs once since Diddy's incarceration. During that meeting, Mr. Spencer told Diddy when he was at his best, he was the brightest light our culture ever enjoyed. Somewhere along the way, he got too enamored with the power and lost his way. He responded that he thought that fame and fortune brought you notoriety, but he realized the magnitude of the obligation and responsibility required. It is clear that the last year has given Diddy the outlook shift, the break, and the sobriety that he has so badly needed. He reflected to the probation officer how the legal process and incarceration has affected his outlook on life. So this is apparently allegedly, quote, straight from Diddy. There's a price you have to pay if you're blessed with success. This is something I never knew or accepted. Success has a steep price, and that price is responsibility. Responsibility is a scary word. Most humans dread responsibility. I know I did. I really thought success and money gave me freedom to do whatever I wanted to do with no real consequences. I had to learn the hard way. Yeah, by serving your 5 to 7. You don't get to walk out today, buddy. It's unfortunate it took me being incarcerated to learn this valuable lesson. I have to admit that I have been irresponsible with the life God blessed me with. I have been irresponsible with the gifts that God blessed me with. I ran with the responsibility. Heavy is the head that wears the crown. But just no, just stop. The crown fell off, doofus. You don't got the crown no more. The crown fell. You don't have a crown no more. It fell off. It's on the ground. I used to call myself a king, but I did not act like a king. Yeah, you did. You act like a mad king. I didn't act like a man. If you don't pay the price, you eventually fail. I have learned that everything I say and everything I do matters. It all matters. I have a responsibility for it all. With responsibility comes sacrifice. In the future, I will sacrifice what want to do for what is best for me, for all, not just me. I will be selfless instead of selfish. Selfishness is a disease. Selflessness is a gift. He's even talking to Russell Simmons, girl. This situation has made me become a man that knows and understands his responsibilities, a man that is ready to sacrifice. Okay, well then sacrifice by doing your 5 to 7 and move along. You're clearly not accepting the responsibility because you're trying to be acquitted, stupid. It's just this don't add up. A man that is ready to pay the price. Well, you're not ready to pay the price because you're still trying to get out of your guilty verdict. So miss me with it. Okay, anyway, let's go back to Twitter and see if anything has been said. I didn't even make it to the Janice Combs letter, but I thought y'all would want to hear that. I didn't even see that before. That was the first time I ever came across that. Like what Kay said, he's Baphomet. Seriously. Okay, let's see where we are in these arguments, these oral arguments going on. Okay. So just to remind you, the most recent tweet we read, this was 9 minutes ago. It's Diddy's lawyer now making her arguments about the First Amendment right to a freak off and to record it or whatever. Oh my God. At trial, they emphasized that it was choreographed, Your Honor. This is Diddy's lawyer, Shapiro. That there was role playing in wigs. It was filmed. So it's covered by the First Amendment. But Diddy also had a right as a consumer of amateur pornography. Jane even bought him a TV so they could watch the videos together. The judge cuts her off. Shapiro, how does that apply to the transportation? What are we talking about here? She said, well, if the intent included filming and watching it later. He said, okay, so it's not prostitution if it's recorded and watched later? Shapiro said, well, you wouldn't have to find this, Your Honor. This is a unique case. The judge said, okay, but the prosecutor. Yeah, exactly. Thank you. The judge goes, okay, yeah, Diddy's lawyer, but didn't you hear the prosecutor point out that the government has other interests, including transportation across state lines? She said, well, in that case, Your Honor, then you would have to look at the conduct of this particular defendant. Judge said, okay, let me look at it right quick. Let me look at his conduct. What about the drug use? He crossed state lines or made someone else cross state lines for the purpose of this. What about the transportation? She's like, well, you have to look at the conduct of the defendant. She's like, and the judge's like, okay, well, I'm looking at the conduct. And what about that drug use? Doesn't the government have an interest in stopping the transportation of substances across state lines? I mean, I think we all learned that in law school. She's like, no, the only drug charge here was related to the RICO charge. And Diddy was acquitted of that, Your Honor. So the Department of Justice policy doesn't even say what Ms. Slavic is saying. It says that the statute should only be used on prostitution as a business or the king of minors. But the policy is not the same thing as a law. Enforcement policy can change from administration to administration. So they can decide tomorrow to break their own policy. It's their own policy. They can break it if they want. Heavy is the head that wears the crown, this lunatic had the freaking audacity to say. It actually made my stomach turn that he's still trying to shirk responsibility while saying in black and white letters that he is willing to accept his responsibility. It's like, oh, so you lying. Okay, got it. So they can't both be true. I'm looking for the letters. This is a long AF filing. I mean, it's like 150-page filing just without any. Golly, this is a very expensive. I bet you this filing cost in billable hours more than $100,000. Like a 15-20 page filing, it's about $1,000 a page. $25,000 for a 25-page filing is usually what it ends up costing at like a mid-sized big law firm. And these are the cream of the crop, the heaviest of hitters. God damn. Okay. So I finally found the part where there are exhibits. Let's make sure we're not missing any arguments. Okay, so if you're following the Tekashi 69, which I'm not, but Inner City Press is tweeting about it in case you are, I'll just read it since there's no new tweets on the Diddy thing yet. He said, outcome on 6/9. There will be a sentencing on November 4th that Inner City Press should be able to live tweet on 3 violations. The battery was pled down, so he did plea to guilty to a misdemeanor. Prosecutors asked to remand, but the judge said no. Also, he's not allowed to have a phone. Okay, let's do this. See if there's anything new here. No, there's not. I do want to put up a poll. And the poll is going to be, do y'all want me to go live later on David stuff? New David findings from today, or should I just wait till tomorrow? Okay, I did the poll. So if y'all could please vote in the poll. Okay. Meanwhile, this was just docketed after Inner City Press moved to unseal sentencing memo in Honduras narco JOH Victor Hugo Diaz Morales case, waiting to see what the unredacted version will show. Order, submit unredacted version to Chambers via Chambers email and file a redacted version on the docket. Okay. I don't know anything about that case. Okay, we do have a new tweet in the Diddy oral arguments for the motion for a new trial / acquittal. Acquittal / new trial. She had last said the only substance charge here was related to the RICO charge, of which Mr. Combs was acquitted. Department of Justice policy doesn't even say what Ms. Slavic says. It says the statute should really only be used on institution as a business or the king of minors. The judge said, okay, well, those were my questions. So, Ms. Shapiro, Diddy's lawyer, said, I believe that the assistant U.S. attorney said the 2 women testified they were paying for restitution. We must have been at a different trial, Your Honor. She really thought she ate. I don't remember either woman saying they were involved in restitution. Yeah, well, the thing about restitution is you don't have to actually say that you're involved in it to be found guilty of it. And the issue is a jury already found Diddy guilty of this. A jury already found him guilty of transportation for the purposes of restitution. He's guilty. He's a convicted, guilty restitutor. Okay? Whether it's from the pandering, whether it was from being a John, whether it was from being a producer, whether it be a whatever in the hell, he already got convicted. He is guilty. He is guilty of restitution. Guilty. Guilty. He's guilty. He is guilty. He's already been found guilty. This lady is trying to relitigate. You don't see the government in here saying, Your Honor, we need to overturn the verdict because we had such good evidence. The jury should have listened to us. This isn't the time for that. This isn't the moment for that. Judge said, let me ask you this. A businessman takes one of his clients to a brothel and pays a prostitute to have relations with his client. Okay, businessman, he brings client Joe over to the brothel, pays for everything, leaves Joe at the brothel. Joe has fun with somebody over there. Is that not prostitution? This dense ass idiot says, is he a voyeur as well? I could not do this job. I don't have enough dishonesty in me to, with a straight face, say this stupid crap. I just don't have it. I don't have it in me. I just don't. The Mann Act has racist origins, Your Honor. He's already rejected this argument. If you want to change the Mann Act, you need to get the legislator to do it, the legislative branch. It's nothing to do that the judge can do. The Mann Act has racist origins, Your Honor. Even 100 years ago, the statute was criticized by many Supreme Court justices. Many juries refused to enforce it. This statute is embarrassing to the U.S. I submit respectfully. No, you, Alexandra, are embarrassing to the U.S. because the whole entire world watched this case, and the whole entire world is watching you with a straight face say that Diddy should be allowed to do the debauched and degenerated things that he did, which he is a convicted criminal, by the way, for doing. He stands convicted criminal for doing it. Let's call it what it is. He's a convicted criminal guilty of crimes, 2 of them. And the crime is prostitution, interstate travel for the purpose of prostitution. What is embarrassing is people like you who are willing to literally sell your mind, body, soul, and spirit for the paycheck. Don't matter to you, nothing but the paycheck, huh? Don't care about nothing but what the paycheck says. What's really, truly embarrassing to the United States is that bullshit mentality. What's embarrassing to the United States, don't even get started. There's genocides going on, and all of our leaders are bought and paid for by the terrorists. Imagine it. I shouldn't say all. Some of them aren't. Some of them are not. That's embarrassing. But you in here arguing that Diddy ought to be able to rub some other man's stuff on his nipples. You saying it's embarrassing to outlaw prostitution, girl. Please. What's embarrassing is you. We got another tweet. Diddy should be acquitted of the Mann Act counts that he was found guilty by a jury after a 2-month-long trial. We should just get rid of that now. The whole two months long trial was just for fun. We just did that for fun. Just overturn that, Your Honor. Let's just not worry about that. The assistant U.S. attorney said, okay, thanks. That was cute. Back to reality. The purpose of the Mann Act has no impact on the First Amendment activities. The arguments about Department of Justice policy, those have already been argued. There was a motion to dismiss on that. They already argued that. You already denied their motion to dismiss. You already denied it, Your Honor. What are they doing in here today? They're wasting everyone's time. They claim there should be no concern about secondary effects because it was behind closed doors. But that's the point, Your Honor. Cassie was being punched, kicked, beaten. Diddy has the burden to show the evidence wasn't sufficient, and he has not met that burden. The evidence was sufficient. He was found guilty. The jury, Alexandra Shapiro's over there saying, a lot of people juries don't even apply this. It's embarrassing to the United States. A lot of juries won't even apply it. Well, guess what, doofus? This jury applied it. Not once, but twice against your client. So what other juries did, whether they applied it or not, is irrelevant. Your client was found guilty by a jury of his peers that he helped to select, hired lawyers to select. He was found not guilty on the other ones. Clearly, the jury found him unequivocally guilty. And now she's like, well, I don't like that. I don't like that. It's embarrassing. Okay, well, you're embarrassing. Where did that get us? Absolutely nowhere. Moving on. The assistant U.S. attorney said, Your Honor, Cassie and Jane both testified. Although they did not want to be having relations with others, they Had to, for days. He planned the encounters. He choreographed the encounters for his own pleasure. If the escort couldn't perform, he either wasn't paid or was paid less. This went on for 15 years. The evidence is sufficient, Your Honor. The defendant's motion should be denied. Thank you, the judge says. Anything about sentencing if the motion is not granted? Okay, so the judge says, all right, I'm going to take this under advisement. Hold on, I have to block an idiot in my chat. Diddy is getting prison time. I just need to let y'all know Diddy is going to go to prison, even if it's for a few months. He's definitely not walking out on Friday. And I just feel honestly kind of bad for like these poor delusional souls out here who really get their hopes up. I mean, they were screaming and screeching at me because I was trying to tell them the judge is allowed to take certain things into consideration for sentencing. They were screaming violently, aggressively, like very close to me. I could almost smell their breath because they get this delusion land in their poor little weak minds with underdeveloped frontal lobes. These particular individuals, specific and particular individuals, they get their hopes up for some shit that's never going to happen. There was somebody just now in my live chat that said, y'all are going to be so mad when Diddy gets probation. First of all, he's not getting probation. Y'all are delusional. Y'all are delusional. Second of all, it is not going to make me mad if Diddy gets probation. He's not getting probation. He's going to be going to prison where he belongs. But there is a checklist. There is a checklist. There is absolutely no way at all whatsoever that Diddy's not going to prison. So people thinking he's walking today, poor things. Anyway, the judge is saying, all right, so in the case that I deny this motion for acquittal, which is probably going to happen, he's probably going to deny it because these are stupid arguments and Diddy just wasted about $250,000 trying to make them. In my opinion, I mean, that's my estimation. I don't really know. I didn't check his books or anything. He didn't tell me. And even if he did, I think he lies. Yeah. Okay. So the judge is like, anything else? If I don't grant this motion, do you want to talk about anything for sentencing? You want to save that till Friday? She wants to save it. She said nothing else. Okay. The judge said, okay, I'll decide later. Bye. Court adjourned. Court adjourned. So, does it matter to me if Diddy never serves a single another moment in jail? No, doesn't matter to me. I don't live over there. It definitely matters to his victims. Shout out to my cousin Neem. I was in his live chat yesterday again. I gotta watch your video about the Munchie Bee. The Munchie Bee, I gotta watch that. But I am making a video about No Jumper right now. I'm making a video about No Jumper right now. I recorded it this morning, so I do need to get off here and go edit that. Let me check my poll. What did y'all say in the poll? Should I do David updates later this afternoon? Or, oh, look, my other cousin Uda. Let's go through his. He was actually nice to me. He does not.
Let's see how that thing is without Uda anyway. You're going to see the energy that I bring out there. Shit dry without me.
I'm sorry, y'all. I don't know anything about him. I don't know him from Adam. But what I can tell you is he was not in any way mean to me at court. He was actually one of the people who's very nice to me. And he even told me, with my fiance too, like I was with my fiance the whole time. He even told me, he was like, if anybody gives you any troubles, just holler my name 3 times and I will appear. He was very nice to me. I would say, like, I don't know how he would characterize himself. I would say he's maybe like more pro Diddy, which like absolutely do not agree with him on that. But that being said, like I like him. He was very nice to me in person, and that goes a long way. Anyway, let's go in his
I
live.
tell you, bro, God plays too as well, right? But I will be doing some here. I'm going to go on the inner city press real quick though, because he's been doing some updates. So we're gonna do some quick updates on this real quick. All right. So starting from 11:04, from he came in, he said, "Look, Combs is still in his holding cell."
So he's doing that. Okay.
Take
I'm gonna mute it. I want to go to see my poll though, real quick. What y'all voted in it to see if I'm gonna be doing coming back on here later, live or not.
Lynn Bryan still acting below. Prosecutor stone face in the front row at the moment.
Checking my poll. What y'all voted in? Okay, 483 votes, and 75% said yes. Okay. So I guess I'm gonna be going. I guess I'm gonna be going live a little later on the David stuff. There has been quite a few things coming out on the David thing. I do already have a little bit like a next time coverage type of situation. Hold on. So I already have a few things. I can tell y'all what those are. Let me see. Neighbor saying that it smelled like sewage for like a month. That car. Somebody sending me a tip about some bloody sheets that were behind him on a live stream. Very good observation. And then some new information coming out about how Celeste maybe got into an unknown car, according to some surveillance footage. There's a lot of that stuff going on. So those are a few of the things that are going on. I will be going live later this afternoon. I do have a no jumper video. Also, Nova. Put a 2 in the chat if you remember the Nova documentary. I have Nova Part 2 coming out. I believe it should be coming out today. I believe it should be coming out today. And so, yes, Nova Part 2 coming out today. I have this no jumper video. I have a casualty to report from no jumper. Don't worry, it's not that serious. Nobody died. Neem did a video on it earlier. What did you do the video on earlier, Neem? But anyway, if you need to catch up on the goings on that were going on, I have made it into a playlist, the David playlist, and I have y'all going over there to Uda's chat. Again, I don't know if y'all are going to agree with his opinions, but I have y'all going over there, number one, to like, expose you to a different opinion. Number two, because he was really nice to me in person whenever these belligerent buffoons were being like aggressive and, in my opinion, like borderline violent and infringing upon my rights. So if you could just go over there, even if you don't stay, I got y'all redirecting over there. Just go say like, cousin invasion or whatever, XOXO. And then, if you're not liking what you're hearing over there, you can leave. But I like him. I think he's like a nice person. He was very nice to me. Walaikum salam and all of that. Salam alaikum and all of that. Thank you, Sour Girl, for the $1.99 super chat. Thank you, Kim Fine, for the $1.99 for Diddy getting sentenced on Mean Girls Day. Yeah. Exactly. What was it? May. No, we got sentenced on like June 5th. What's Mean Girl? I thought Mean Girls Day was in April. Oh no, that's Miss Congeniality Day. Slay. Thank you for the $1.99. Kim, fine. Shout out to Luis becoming a member for 5 months. Thanks so much, Hibiscus Rose, for the $9.99. You rock, BJ. I enjoy your lives. Thank you so much. Shout out to my sister, B Babe, for the $10 super chat. Love you. You're the best role model a sister could ask for. Doesn't that just make it all worth it? I could die tomorrow. I could die right now. I was a good sister role model. What else is there? I don't want to die, girl, tomorrow. But I'm packed up, ready to go up. Make no mistake. Thank you for the $10, little sister. Thank you, Wendy, for the $4.99. BJ, you slay. Love you. You're green-eyed cuz. High fives, hearts. Thank you so much for that. Thanks so much, Sour Girl, for another $1.99. Love your channel. You are awesome. Thank you so much. Thank you so much for all the support of the channel. All right, y'all go say something nice to Uda, and I'll be back on here live later. In the meantime, facts ain't defamation. Neither are opinions. Love you, Minnie. Okay, bye.